Welcome to Blizzard Fire. We hope this video helps fire up your solution.
You start by verifying the takedown. Note the notice date, platform, and exact URL or content ID so you know what's at stake. Once done, collect the complainant's contact details and any proof of permission or ownership. If you have a license or fair use argument, prepare those documents. Otherwise, decide whether to remove the material, file a counter notice, or open communications. Make sure to act quickly. Platform timelines, like 10 to 14 days, often matter for next steps. Now, prepare a counter notice if you believe the takedown was wrongful. Write a clear statement that includes your contact info, a description of the removed material, and a declaration under penalty of perjury asserting good faith. Attach supporting evidence, agreements, timestamps, or source files to show ownership or authorization. Then submit through the platform's specified counter notice form or the email in the notice. Remember, the complainant then has a set time to sue. This is a legal process. Proceed carefully. Finish by monitoring the platform's response. Many restore content after the counter notice period if no lawsuit appears. If the complainant initiates legal action, stop and consult an attorney right away. Preserve all evidence, logs, and communications because they matter in court. If the platform rejects your counter notice, escalate through support channels and document every step. Troubleshooting tip: if things go wrong, maintain a timeline and copies of all filings. This ensures you can show good faith and protects your position.
Thanks for watching. If you found this helpful, don't forget to like and subscribe.